name is Lulanga Sydney. I'm going to make some presentation on mercantile law. Mercantile law is also known as commercial law or civil law. It mostly looks at trade. So in other places they call it the law of traders or merchants. So before we begin this particular lesson, let's look at the learning outcomes. Learning outcomes are the competencies that you'll be expected to get at the end of this course, lesson, or unit. These are competencies. So at the end of this course, you should be able to explain the sources of law and discuss the principles of common law system. You should also be able to interpret, explain, and discuss the law of contract, agency, employment, and tort. You should also be able to recite or cite relevant case law and discern the legal principles enunciated in such case laws. And then you should also be able to illustrate and discriminate the different concepts of legal personality. So what is mercantile law? Mercantile law is that branch of law which consists of laws relating to trade, industry, and commerce. It's one of the key branches of civil law or commercial law. Sometimes mercantile law is known as civil law or commercial law. Commercial because it deals with business. Civil because it deals with personalities or two different persons that you find in society, the artificial person and the natural person. So let's look at the scope of mercantile law. The scope of mercantile law is very wide and varied depending on the situation or the environment where the business transaction takes place. Different countries have different laws relating to trade, but there are also international treaties or international understandings, and there are also international laws which crisscross different boundaries. So mercantile law includes law relating to contracts, partnerships, sale of goods, negotiable instruments, companies, insolvency, insurance, carriage of goods. So all these are issues to do with trade. It also looks at the study of rights and obligations arising from trade transactions between different traders. So when you look at any transaction, any contract, any kind of understanding between traders, it could be natural persons, the owners of the businesses, or artificial business persons, which has to do with entities, companies, institutions. So that is covered by mercantile law. So mercantile persons are persons, whether artificial or natural, who carry on commercial transactions. These could be individuals, they could be partnerships. Remember, partnerships is between 2 and 50 people, or joint stock companies. For example, one company joining with another company, trading together. So it's essential that people who are involved in trade come to know what law they can apply or what law binds them to certain contracts, certain understandings. So when they go into contracts, it should be built on legal terms. So they should be contracts are legal understandings, and they can be used in the court of law in case of any dispute. So it helps the merchants or traders to avoid conflicts when it comes to business contacts. So what are the main sources of mercantile law? There are 4 sources. There's the English mercantile law, statute law, judicial decisions, customs, and usage. So those are the 4 sources of mercantile law. Now, the English mercantile law, English, it comes mostly from Anglo-Saxon background. It is a source of most of the trade law, and most of the English law has been incorporated through statutes and judicial decisions. Judicial decisions are those landmark cases that or decisions that are made by judges, and mostly they are referred to when a similar or same occurrence happens. Statutes, they have to do with written laws passed through Parliament, depending on which situation that you refer to. So the sources of English law, for example, the first one is the common law, which is also known as the judge-made law. This is based on customs and practices handed down from generation to generation. It is the oldest unwritten law. So this is mostly because of tradition, and everybody follows. So this has been happening over a period of time, and it's referred to, and people come to a certain understanding and respect because of this unwritten law. Equity is also unwritten law. It's based on concepts of justice. So equity looks at similarities and differences that may happen or that may be noticed between persons or institutions, that everybody should be treated fairly, and there should be justice in any kind of business transaction or business understanding. And if there are any deficiencies, they should be dealt with accordingly. So the Judicial Acts of 1873, 1875 abolished the distinction between common law and equity. So now these are all applied to cases. Statute law, it mostly happens, as we have discussed, with the Acts of Parliament. Parliament consists, for example, in Namibia, the National Assembly plus the presence of the President. It makes into Parliament. So the Parliament, when the law is passed and the President signs it, it becomes a statute. It's the most superior law and the most powerful source of law. It overrides any rule of common law or equity. Okay. Now, case law. This is also an important source of the English mercantile law. It's built upon the decisions of judges. It's based on the principle that what has been decided in area case is binding in similar future case, unless there is a change in the circumstances of the case. So this looks at similarities that happen, or the cases that look the same, and the judgment that was made in the previous case holds in the current case. And then there's the law merchant or lex mercantilia. A lex mercantilia is also known as the important source of English mercantile law. A merchant law consists of legal principles based on customs and usage. They developed first as a separate system of law and subsequently became part of the common law. A statute law is mostly based or passed by Parliament and signed by the President, and then it becomes an act of Parliament or a statute. Most of the Namibian laws, as we have mentioned already, are embodied in the various acts passed by Parliament. Now, judicial decisions are also called case laws. They are referred to as precedences. So you set a precedence, and anything that comes in a similar circumstance or similar case is the decision is made based on the previous decision that is holding, unless the circumstances change. And this is binding on all courts having jurisdiction lower than that of the court. For example, if the Supreme Court or the High Court makes a certain decision, any other court, magistrate court, lower court, will follow what has been decided by the High Court or Supreme Court. These are landmark cases, and anything that falls in the similar line will have the similar judgment unless circumstances change. Now, what about customs and usage? These play an important role in regulating business transactions. A well-recognized custom way of doing things, mostly carried on by generation to generation. It may be over years, it may be over centuries, and its usage can even override the statute law. So the way people have been doing things and people are accustomed to that may be considered higher or to override a law that has been passed by Parliament. But these are exceptional cases, they are not everyday cases. So most of the business customs or usage has already been codified and given legal sanctions in Namibia. And some of them have been rectified by the decisions of the competent courts of law. Okay? Now let's look at the nature and the scope of mercantile law. There are basic elements of the common law system and the language it uses with the domestic and the international market. So there's a language, the business language, that mercantile law adapts and uses for everybody, no matter which community or society, ethnic group, whatever groupings you belong to. So there's an international business law that everybody understands. Then the sources of law, common law and equity, statutes and delegated legislation or statutory interpretation goes across board. So there's something that everybody refers to when it comes to mercantile law. For example, a business person in Namibia will refer to the same law like a businessman in Malaysia because of the common elements or the sources of law that binds both traders. So when these traders are trading to each other, they will apply international law, which will be based on the mercantile law and also the different statutes according to the environment that they find themselves. So the difference between civil and in the common law sense and criminal law, we see it as also the source that we can use when it comes to mercantile law. The administration of the law. Okay, how is the law supposed to be adhered to? Can this law be interpreted differently according to the circumstances? So that is all applied in mercantile law. Then the court system and the alternative dispute resolution. Mostly this comes out in the contracts that people sign. Then the personnel of the law, for example, the judges, the barristers, the lawyers, the solicitors, the legal executives, and the paralegals. Okay, so all these help us to interpret the different laws that are out there, or to ensure that fairness, justice comes through when it comes to business. Now, the application of the court's decisions. Mostly, what is applied is the case law. You cite, the businessman is supposed to apply the case law, cite facts and ratios, and where possible contrasting cases, and show the decisions that can come from the hypothetical situations. So facts play a major role. The law or the decisions that have been made before, what is the rationale behind all this? Are there any contrasting cases that have happened before? What about different scenarios where different decisions have been made? And then we come up with the hypothetical situations, and they help us to understand the current situations. And then the law of association, the separate legal entity concept and its implication for the business and the customer and the final consumer. So all these they have something in common, but they are also looking at the issue from different angles, depending on the various interests that each one of them has. Then the recognition of the sole trader. We need to understand the definition of a sole trader, what can lead to the creation of sole trade, the trading position, the legal liabilities. Then we look at the partnerships. Partnerships, we said they are between 2 and 50 people. We look at the essential elements in there, the contracts that are signed, then the relationship with the partners between themselves and to the outside world, and any kind of obligations that may be there. Then we look at different types of companies. Okay, we need to clarify what these companies are, what legal bindings these companies have. For example, the limited companies, unlimited companies, the memorandum of association and articles of associations, the doctrine of ultra vires and the recent changes in the law, the nature and the form of company securities, and the directors, what are the responsibilities of the directors, what are the regulations governing the powers, and then how do these companies manage, or how are they managed, and then the company meetings, who makes decisions or key decisions in this company. Okay, what is the role of the directors, what's the role of management, all that comes out in law. We need to understand it. Then the basic law of contract, the essentials of a valid contract, terms, conditions, exclusion clauses, mistakes or misrepresentations, undue influence, inside trading. We need to understand all that. Contracts in restraint of trade, for example. Then the discharge of the contract. How do you discharge the contract? How do you terminate the contract? All that comes in law of contract. Now, in law of contract, we also look at the remedies in common law, the equity for breach of law. So, for example, if the trader in Namibia and the trader in Malaysia, there is a misunderstanding, how do they ensure that none of them is disadvantaged or is disgruntled from the business or feels cheated? So the law of equity, we need to apply that so that justice, fairness is put into play when it comes to trade. Then what about the consumer protection? Okay, so there's a law to protect the consumers. The consumers not to be misled, or the consumers not to feel cheated from a business deal. What about special contracts? The seller and the supplier of goods and hire purchase. We need to understand what this is all about. What are special contracts? How can I buy goods in Malaysia and I'm in Namibia and ensure that the correct goods are delivered at my doorstep or at my company? What about hire purchase? If I go into a shop, a furniture shop, I want to buy a sofa set, how can I know how much I'm supposed to pay per month and how long is this contract? What's the difference between cash sale and hire purchase? All that, the information should be given and I should feel protected. Then conditions and warranties, I should know if there's a guarantee to the item. If there's a warranty, what does the warranty cover? What does the guarantee cover? And then transfer of title of goods and risks associated with such transfer, delivery and acceptance of goods. All that needs to be clarified. And it's only clarified through the law of merchant or mercantile law. Then what are the remedies? For example, if I buy a sofa set and then I realize that it's damaged, can I go back to the shop and exchange it, or can I be given back the money? I need to know. Okay. What about the laws? The loans. I go to a place where they offer loans, whether it's a cash loan, a bank. What protection do I have as a customer? What protection does the bank have? in order to recover their money. Okay, all that needs to be it is clarified in the law of contract. What about law of agency? We need to understand who is an agent. We need to know how an agent is created, the authority of the agent, the rights and duties of the principal and the agent, the types of agencies. So all that we need it's clarified in the law of agency. And the termination of the agency contracts, remedies, principles relating to customer law, common law, statutory legal principles, and the case law. All that comes under the law of agency. What about the law of employment and industrial relations? Now, there we need to understand the relationship that exists between employer, employee, other parties, for example, employer association, employee represented by the unions, and the interest that is played by the government. So we need to understand the contract of employment, what needs to be put in the contract, how can a contract be acceptable, or the contract, the terms of the contract make it very difficult for the employee to accept the terms and conditions. So the contract of employment should be very clear, in a very clear language, in a legal understanding that both the employer and the employee are protected, both their interests are protected. And then if there's a dispute, what's the role of the employment tribunals or appeals court? How can we use it? In which circumstances may we not use any of them? And then what about the workplace law? What are the policies in place? What law binds these employees to the workplace? What laws or law binds an employer to ensure that the employees are treated well and they are treated humanly? What about health and safety at work? It all comes under the law of employment. And then there's also a law regarding bills of exchange. For example, in Namibia, we may use Namibian dollars. In Angola, they may use Kwanza. So a Namibian businessman who trades with an Angolan, what type of money or what bill of exchange will they use? Okay, somebody who buys the item, how will that person pay? So we need to accept, to understand the concept of negotiability, where different parties are able to negotiate and come to an understanding that this is the way the payment will be made. So we need to understand the purpose of a bill of exchange, the duties and liabilities of the parties involved, the relationships of bankers and customers, protection of the banker himself and the protection of the customer, and then the charge cards and the credit cards, the debit cards, when can you use them, when can you use a credit card and ensure that you are not conned or you are not frustrated in the process. The law of tort mostly covers issues about damage or liability when it comes to the goods. What about malice or general defenses in tort? What about the capacity of the parties involved? It's all covered in the law of tort. Now, the law of tort has classes. So there are different classes of tort, defenses, and remedies that need to be considered when it comes to law of tort. For example, when we are looking at trespass, a business premise and someone who is not supposed to be on the premise happens to be there, it can be charged by for trespass, and that is found in the law of tort. A former employee, for example, who has been dismissed and the employer does not want the presence of that employee in the workplace, and the employee comes in, can be charged for trespass. What about nuisance? When you become a public nuisance, you can also be charged within the law of tort. What about negligence? And a driver who is supposed to transport employees from point A to point B safely is involved in a road accident and some employees are injured, or some even die, and it's found that it was the driver's fault, he can be charged within the law of tort for negligence. Defamation, where someone, an employee or employer, or just a colleague spends time, resources to speak ill of an organization or individuals within the organization, deaden the name, making it very difficult for these people to trade. It can be dealt with in the law of tort. Deceit, not being truthful. For example, a trader in Malaysia does not provide all the necessary information to a trade or to a customer in Namibia about, for example, the quality of the product, how long that product will take to reach the destination, all kinds of information that may be needed by this particular customer or trader is hidden, and it's done in such a way that this person does not access the needed information. That can be done within the law of tort. Then there is also breach of statutory duty, and then what are the limitations of actions or actions that can be carried out. So in this course, what we covered, we defined what mercantile law is, and we said it's a legal code that governs the operations of both banks and varied businesses, mostly to do with business transactions. It looks at agreements, it looks at contracts, copyright rights, franchising, insurance, licensing, patents, shipping, transport, trademarks, and the like. So mercantile law protects both the trader and the customer, or traders in any kind of business transactions. Mercantile law holds everybody accountable, and it brings about the issue of equity, fairness in trade, honesty, and traders being able to understand each other and speak the same mercantile or trade language, which is based on law.